The process to file an appeal of a district court order in Nevada begins with a filing of a notice of appeal. That notice of appeal is a pretty simple document. It pretty much just lists the name and date of the order or orders that you're appealing from, and it has to be filed within 30 days of the notice of entry of that order. Now, once you filed that notice of appeal, it opens up an appeal case, and if it's a proper appeal, it also divests the district court of jurisdiction, meaning they can no longer modify their orders. They can enforce them, but they can't modify orders once you actually have an active appeal case started. The appeal case will proceed through the system in the Nevada Supreme Court, and if it's not a child custody case, it will get presumptively assigned to a settlement program where the parties will attempt to reach a settlement. If it's a child custody case or a termination of parental rights case, then it's exempted from that program. Now, once you either go through the settlement program and don't settle, or you're exempted from it and you bypass it, after that, there's a order that you'll receive from the Nevada Supreme Court that requires the ordering of transcripts. If you had hearings or court proceedings, they need the transcripts from those. So you have a time period to order those transcripts. And then there'll be an order that spells out the deadlines for the opening brief and the continuing briefing in that case. So you receive that order and you know your deadlines. So you order the transcripts, you get your transcripts, so you have them to review and incorporate into the brief. You then have a deadline for your opening brief. In your brief, you're going to have to cite to the record, which you prepare in the form of an appendix. You're going to cite to those transcripts, and you're going to detail out the important facts and things that happened in your case, and then make arguments as to why there was an error in the district court. Once that brief is filed, then the other side has a time period that's spelled out for them to file an answering brief. After their answering brief, you then have the opportunity to file a reply brief to their answer as well. And at that point, then the briefing is completed. Now, if your case is one that is a family law case or other type of case that's presumptively assigned to the Court of Appeals, they will then decide at that point if the case is going to be transferred to the Court of Appeals or stay with the Nevada Supreme Court. Some reasons why it might stay with the Nevada Supreme Court is if it's an issue of public policy, there's no law on the subject, something that's important enough for the Supreme Court to need to review it. Otherwise, family law cases are presumptively pushed down to the Court of Appeals. So at that point, you'll receive a notice of transfer to the Court of Appeals. And that's when you know, okay, they reviewed it, it's been transferred to the Court of Appeals. At this point, then you're just waiting. Some cases will go to oral arguments, and so you will receive a notice scheduling the oral arguments, but those are rare. If your case, one or both sides has a pro bono attorney through the pro bono program, those ones generally get scheduled for oral arguments if both sides have attorneys. But otherwise, it's not as common to have oral arguments than to just go straight to a decision. And so once you have oral arguments, or if they decide not to do them, then you're just waiting for a decision. And at some point, and with the child custody cases, they have a much faster deadline. It's not a hard and fast deadline, but a expected deadline to get the decisions out sooner. At some point, you'll receive the decision from the appeal.